Okay, we're going to start the workshop now. And, oh, I thought it was. Okay.
What's on now, isn't it?
No, I guess not. We got to look for the red. Okay. I could see the blue. All right. I want to thank specifically the planning board. I want to make sure you hear me when I say thank you. We appreciate all the work you've done to date, and we appreciate the planning department, specifically Jim and Linda, helping out and doing your thing and moving this along. I sent out a memo asking, and I don't know if everybody's seen it, but basically if we could kind of get into, as Jim put it, get our heads around this, so to speak. And you've already started thinking about this, and so the council needs to think along with you and think about tonight. Maybe we can narrow things down and sort of focus on what can we get done before November, because the council's going to change slightly. There's going to be some new people coming on, and what can we realistically get done. And the other thing is, of course, even if there wasn't an election in November, it's going to take quite a while to get through this anyway. But Jim, could you tell me the date, the end? When is the 18 months up? Do you remember that deadline? Is it right from when they approved it?
It's probably like March of 2013. Yeah.
Really? Oh, that's right around the corner.
Wait a minute.
No, it can't be.
Well, the comprehensive plan was approved in September of 2011.
Right.
So September of 2012 would be 12 months. And then 6 more, March.
And how hard do they hold you to that? Seeing as nobody else does
Don't
comp
they usually,
plans?
depends on your progress?
Yeah,
Well,
I mean, I'm sorry, they haven't done comp plans, and some towns don't even do them, so it seems to me it's not as serious as March, so it isn't like we're under the gun.
I think they'd like to see it done as quickly as possible.
Sure.
Keep in mind, the 2011 legislative session, okay, not this most recent one, but the one prior to that, they changed the law such that the 18-month period really doesn't apply anymore. What they're requiring now is that when you submit a comprehensive plan to them for approval, your implementation program, which is a part of that plan, has to spell out in it a timetable for towns to get their zoning consistent with the comprehensive plan. So otherwise they won't approve it. Now, the reason why we don't have that in our plan now is because I submitted this thing to the state officially prior to that law being put into effect in 2011.
Perfect.
So I guess technically we're under the 18-month time frame.
I think technically we're into as soon as we can.
Yeah.
Madam President, if I can, the law actually allows council to amend the zoning form with a reasonable time as the language. So what does that mean? It's vaguer than 18 months. Who knows what reasonable time is? Based upon past practices, many people argue vehemently that 18 months seems pretty reasonable since that's what the law was. What the law says right now, reasonable time. So what does it mean? It's open for interpretation. There's no way to say we need to have it done by March 13, 2015, or anything. It's reasonable time.
So I think this legislation is relatively new, so I'm sure that it's never been litigated, so no court has come up with what they consider a reasonable time. I would assume that's correct.
That's true, Mr. Dollars. However, I would add that in most instances where you're applying that kind of thing, there usually is some kind of sword that's wielded against the town in the event that you don't apply. In this particular instance, the sword is quite simple. The zoning that exists now is the one that's going to stay in effect. The law used to be when you had your town plan approved, that became basically your zone. And the reason why they wanted you to amend the zoning within 18 months is so that there was no confusion. And zoning matched. That's no longer the case. So if you're dilatory in not bringing your zoning up to consistency with the comp plan, the sort now is your old zoning is going to be applied against you. So your comp plan really won't have any teeth until you amend your zoning. That's the sort. That's what compels you to move and amend your zoning.
Am I correct to assume that in the statement that you just made, that any time that the comprehensive plan and local zoning may conflict, that the comprehensive plan trumps zoning as it's presently adopted?
That's old law. It's no longer the case.
Correct.
The new case is zoning trumps comp plan. Period.
I think the reason I was asking the question is I do think we should move ahead as expeditiously as we can, but I also know that we have a lot of citizens that are going to have a lot of opinions, and I don't want to squelch their comments because we're trying to hurry up and then we do a bad job. So it seems to me I'd like to be as expeditious as possible, understanding that we have very vocal citizens, and I really think they should have the ability to talk with us and discuss with us, and I'm sure that will take some time to get some of that down pat. I don't want to hurry something that is going to be a major problem if we make a decision and then 10 people come in really ticked.
I would agree and add to that, Mr. Powell, that the important thing to keep in mind is that in some instances, it's also going to be very easy to change the zoning for whatever you're choosing, and it makes logical sense, and everybody can see that on paper. But there are going to be some instances where it's controversial, and it's going to be difficult, and those are the ones you're going to want to focus in on so that the decision-making process you're applying isn't just because we think that's right. It's got to be based on something more than that. If you change the zoning, it's going to be based on something that's in particular to your police power, which would be, is it in the interests of the health, safety, and general welfare of the public? Those are the things you have to be thinking about. And you can't just generally say it, so you have to be able to prove it. So it's going to be important to take this review very carefully and methodically.
Well, one of the things in my mind, in thinking the whole process over and talking to Pat Buckley, one of the things that we did with the planning board was when we met September 2011, I think it was, and we finalized in a workshop as far as we could the district use table. And I talked to Al about it too, in that we know that what we have to do is going to take a little while, but one of the things that we could move forward on as soon as we have everything together is the district use table, because the district use table, at least, that offers the town some protection. It's very clear, or should be clear, about what's allowed in town and what isn't. So if you haven't got your zoning quite in order, or the way you want it, at least you've got your district use table up to date. That's right. Yeah. And I understand that one of the issues that Pat and perhaps you discussed was the problem of the district use table if we wanted to, well, why don't I wait until we get to the end of the meeting and on the agenda, and I'll get further into that. As far as the district use table and some legal snafus. But the other thing I wanted to mention is when we do get to the point, and it might be, we'll find out tonight, it might be the next meeting or the meeting after, when we're finally ready to zero in on exit 1, because it'd be nice to take this thing in phases, as Jim has recommended. And when we get to exit 1, one of the things we need to do is all of the people that are on the list, the planning board list, where you guys went through it, Jim went through it, any property that's listed on there, they need to get a letter notifying them of when the meeting's going to be, so that they can come to the workshop and find out, if they want to, what we're doing and looking at, and how we're looking at the property. And if they're fine with it, we'll find out right away. And if there's a wrinkle or a big problem, we'll find out that right away. I'd rather find out what's wrong right away in the beginning. So that, I think, is a good idea. Just notify everybody on that list and ask them if they'd like to join us. So Jim's going to give us a little introduction tonight, kind of make sure we're all on the same page. And what I'd like to do is just let him run through his thing before, and any questions we'll have, we'll get to at the end. Want to go now? Thank you. Oh, you take the time you need to explain everything.
I certainly don't want to repeat too much of the discussion we already had here, but As we know, and again, I'm talking to an audience of planning board, principally planning board people and town councilors, so we know this subject well. I don't see any members of the general public here, but I'm sure they'll be watching the tape.
Mr. Dubs.
Mr. Dubs.
Sorry, I feel like you're one of us. This is the future land use map, which is in the comprehensive plan that was approved by the state last September. Since that time, I've been working with the planning board to identify any inconsistencies between the zoning map, okay, and this future land use map. And in doing so, I looked at every single parcel in town to see how they match up. Once I did that, I broke this project down into 4 components, okay? Exit 1 development area, which is identified by a blue hash line here. I figured we'd take that separately because it's a very, it's an area that is newly identified in our comprehensive plan. It's an area that is being actively developed, and it's going to probably have a profound impact on the town's future going forward. So I took that as phase 1, or component number 1 of this. Component number 2, you're going to see an awful lot of green on this future land use map, and that's open space. We also, now, most of those parcels are either owned by DEM, Nature Conservancy, or Hopkinton Land Trust, or the town of Hopkinton. Basically, they're parcels which probably are not going to have any type of residential, commercial, or manufacturing development. It's going to be any development that would occur probably be in conjunction with open space uses. So I'm proposing, planning board proposed to create another zone called open space zone, which would make all of these properties consistent. Now, there would be active uses in that open space zone as well as passive. So we wouldn't be taking away all of someone's rights to develop a property for, let's say, a golf course or a horseback riding park. That's component 2 of this effort. Component 3 involved amending this future land use map in a manner which is going to be consistent with our underlying zoning. Generally speaking, this map is supposed to drive zoning, not vice versa. However, because we're not dealing with a completely blank slate, we have a lot of land uses that exist out there. I think it's prudent to take a step back and say, well, you know, might we want to take a second look at this map, and instead of making a whole host of non-conforming, legal non-conforming uses, such that people have to go to the zoning board every time they want to put an addition on their home or something like that, it might make sense to amend this map rather than change their zoning. For example, up in here, there's a lot of residential property here, which is very, very limited amount of future subdivision potential up there. You wouldn't know if the zoning was changed on those parcels or not, because it's going to stay the way it is. It's all going to pretty much be rural. So, again, now, component 3 of this, I identified about 40 properties, let's say, that we might want to change the colors on this map and leave the zoning on. Okay. Component number 4, I identified about 30 properties that will have to change the zoning to make it consistent with this map. And again, when time comes, we will go through each and every one of those and see exactly what makes sense. We did so at the planning board level. They seem to feel as though, actually they kind of empowered me to make some common sense changes. And I did so in a manner, keep in mind that because of what Scott just said about zoning is going to rule, okay? If we do nothing and just sit on this, we're gonna be faced with a present zoning. Why is it important to straighten it out? I can think of 2 glaring cases that have come since I've been a planner here. Number 1, a truck stop proposal down here on a parcel that has been classified as a mixed-use village for a number of years, since 2004. But we never changed the zoning on it. The zoning was manufactured, so we had a conflict there. Also up here, we have a comprehensive permit that came to us for affordable housing called Brushy Brook. This parcel, right here, has been open space on a number of future land use maps that preceded this one. And yet the zoning, underlying zoning, is RFR8, it's residential. I don't have to remind anybody that the truck stop issue is now in the courtroom being looked at, and the Brushy Brook proposal is before SHAB, and that could very well wind up in court someday. So it's critical, really, for our own best interest, that we do get our comprehensive plan future land use map and our zoning in sync. I guess with that, I'm gonna leave it so we can dive right into the district use table. I think the approach we're taking here isn't a bad one. Again, we've already discussed the manufacturing / light industry proposed zone. Okay, it's been before the planning board, it's been before the town council. That may be very close to be ready to go. The open space zone that I'm proposing, we will have to take a look at, but again, it's only going to apply to these green parcels. And then the third zone that we might strongly consider establishing is a mixed-use village. Again, I want to flip over here the new proposed future land use map. Without getting into the parcels specifically or any great detail, I just want to show you what the planning board has recommended so far. Okay. Again, this is the exit 1 development area. You'll see as it exists, there's a lot of orange on here, okay, which is mixed use village. The planning board chose to take this section here, which is on the westerly side of Route 3, and now they're proposing to make that manufacturing. Okay? The exception of 2 parts of which are commercial. It's all commercial right now. So actually the planning board has chosen to lessen the amount of mixed-use village in that exit 1 development area, such that there are only 4 parcels, actually 3 parcels and part of a 4th, that are classified mixed-use village. So what we really should do next is create a zone, mixed-use village zone, to define what mixed-use village is, and then it would apply to these areas. So, and also I might add too that in the course of changing this next future land use map, we condensed some of these classifications on here. The state wants to see, ideally, a future land use map should consist of broad categories or classifications, such as manufacturing, right? Commercial. Within that, within your zoning, that's where the details come out. That's where you're really specifying how you want your town developed. You can have different levels or intensities of development of commercial. Matter of fact, manufacturing, if this goes to purple on a future land use map, and we adopt the manufacturing / light industry, we will have 2 classifications that fall in here. Straight manufacturing, which is the heavy manufacturing, and manufacturing light industry. They both fall into this heading. Same thing with our residential. Our residential is yellow. Yellow is our residential. As we all know, we have RFR 80 principally, but we also have R1. Commercial, we have neighborhood business, and we have commercial. So I mean, that would fall within the grid. So this is a much more simple map, and it also gives us as a town more flexibility working within these broad categories to decide what parcels are zoned what. Okay, so it works it's not just something that the state wants to see, it really works to our advantage and gives us latitude. So, this is what the planning board has envisioned for exit 1. When we get to that point, we're not there yet. We want to go through the district use table, and there's some things on the table tonight for discussion. If anybody has any questions as to what the planning board and I have been doing over the last 6 months.
Yeah. Go ahead, Frank. Go right around.
Now, when you want to change that from manufacturing to the purple sections to the mixed-use village, you're changing it from mixed-use village to manufacturing. Is that going to appeal to more broad-based tenants / owners or development, I guess? It seems like it wouldn't, but... Like, who did you consult to kind of figure that out? I guess I'm just wondering.
Well, you know, it's tough for me to speak for the planning board. I mean, they envisioned, even though this is manufacturing, okay, classified manufacturing here, I can say that with certainty that the planning board did not envision this to be zoned straight manufacturing. They envisioned it to be zoned manufacturing light industry. They've seen what's come in there, they like it, and they want more of it. Now, as a planner, I've been thinking about this a little bit more. This area right here, in between Gray Lane and Route 3, when we get to this point, I know we're not there tonight, but this area is zoned commercial right now. So in order to follow through with this, if we wanted manufacturing, we would have to change the zoning of those parcels, okay, those parcels, from commercial to manufacturing light industry. That's why it's important for us to notify those property owners, see how they feel about that change. If they're on board with it, fine. If they would prefer to see their property remain zoned commercial, then maybe the planning board would want to take another look at this and say, well, you know, maybe all this should be red. And then maybe just this should be purple and this should be purple. That's something for future discussion.
I'm just wondering if it affects the value, if somebody owns something and it's switched.
I got a letter here. I asked the tax assessor that
okay.
question.
Oh,
So
good.
let me read it for
Yeah.
the record, and then I'll give it to you, Lisa. So I just asked her if you're changing zone to zone, residential to manufacturing, or commercial, or whatever. And this is what she wrote. To answer your question, there could be valuation changes if a certain property's zoning was changed. Customarily, lots are valued for their highest and best use, which is usually their current use. For example, if a lot with a single-family dwelling in an RFR 80 has a zone change to manufacturing, it could still be assessed as a residential lot since it is currently used that way. If an owner or potential buyer recorded engineering results or plans were submitted to the town for manufacturing purposes, then the value may change because its highest and best use may change. Vacant land values may change upon zoning changes. That can be something that is discussed during the planning stages of the zoning change, so that helps a little bit.
Madam President, if I can add a little to that discussion. The law, I think, is fairly clear in the aspect that no property owner is entitled to the existing zone that they have, number one. Number two, when you make a change to the zone, the issue is not whether or not you're taking away some economic value. The issue is whether you're taking away all economic viability.
Excuse me a minute, can everybody hear back there? You can hear okay? Okay.
So that's the real issue for you. If you reduce the uses to the land, it takes away some value. Well, that's something that you can do so long as you're exercising the police power correctly. You have a reason to do it. However, you can't take away all economic viability of the land because that's a taking. A good example of that is this. Somebody has a parcel. I'll choose one out of thin air. It's residential right now. You decide that you want to make that open space and no use is allowed on that land. What you've done, in essence, when you change the zoning, is you've made that parcel valueless to the owner, because the owner can't do anything. That takes away all economic viability. That's something you can't do. However, if you change the zoning from manufacturing to commercial or commercial to mixed-use village, and you have a reason for doing it. For example, the surrounding area is the exact same use. It makes sense given the area's roadways and current uses, things like that. If you can justify it, then the change is allowed. So that's the analysis that you have to embark upon. There are going to be instances where you change a person's value to their lot by changing their zone. But that's not the real consideration, so long as you're not stripping them of all economic viability, which is the true thing you would be concerned with.
Any other questions, Frank?
No, right now.
Barbara?
Yeah, I have several. The green space on the map, Jim, all the green on the main map, is this permanent or temporary open space? Because we have both temporary farm forest open space by people and we have permanent, Nature Conservancy, Land Trust. Is that permanent or temporary?
I don't know if I classify it permanent or temporary. I would classify it as land that was consistent with previous future land use maps, supplemented by all of the properties owned by, let's say, traditional recreational entities. So, to try to answer your question, yeah, there are some residentially zoned lots here that are probably in our farm, forest, and open space program. That's something entirely.
So effectively, it's the permanent.
Effectively,
It's
yes.
permanent, not temporary. It isn't something that someone can take out of farm, forest, and open space.
Correct.
Okay, that's one question.
Yep.
So all the green is actually the permanent, not the temporary. How do we, I think it's interesting to see how we want to progress. And I think from what Scott has said and you have said, there are parcels that are easy and parcels that are hard. Is it better to start with the easy and just get them out of the way and then concentrate on the hard, or concentrate on the hard whereupon we leave everything else open? Which way do you think the council should work? I would like to get, and I'm saying that because I would like to get some of the easy ones, if everyone's agreed with it, out of the way and gone. Because then we can actually only concentrate on the hard and we don't have other things left hanging. That would be my druther. But I don't know if one way is better than the other, because I do think we're going to have some very hard parcels.
I would agree with you 100%. I would rather tackle the easy things first and get them out of the way by virtue of the number of changes that we've identified here. So the further we can whittle that down, the better. And if you want my opinion as to what would be easy, I would probably say that all of these green things going to open space should be a relatively easy concept to agree on. That'd be number one. Number two, those parcels where we suggested changing the comprehensive plan future land use map to mirror existing zoning would probably be less objected to by the property owner, because you're not really taking their rights away. That's what they got today.
Right.
You're more or less sanctioning
Right.
existing zoning by doing that. So I think those two things, those two of the four things would probably be the easiest. Then we can come back to exit one, because that's a very important thing to look at. I don't think the what the planning board has here is that difficult to negotiate one way or the other. Okay, I think that can be done relatively quickly, especially if we have the consensus of the property owners involved.
Sure.
Great. And then finally, where we have to change zoning on parcels to make it consistent with this map, again, when I made my suggestions to the planning board, I did so with an eye of minimizing controversy from property owners. So of those changes, I think there's probably a handful that the property owners would have an issue with. So that would be the last thing that I would tackle.
So I think it's, just my personal opinion is I'd like to get some of it out of the way early. It just means less people in the audience when people are arguing about a place. So I would prefer to do that if I can. That way we handle the people in a comprehensive fashion. We can certainly finish it by November. I think that was one of Sylvia's concerns on the easier ones, so that they're just in place for the next council. Question three, how do we establish, like in your red zone, how do I know in the red zone that it's commercial or it's neighborhood business?
You would know by looking at your zoning map.
No, I know I have my zoning map, but if I was a developer coming in and the red zones are commercial, great, I'm going to buy 4-23, it's going to be commercial, and then it turns around that it's actually not full commercial, it's neighborhood business, which is a lot less that you can do on it. How does that person know that that's neighborhood business and not commercial, full commercial?
Well, you're 100% correct. You cannot divine all the information that you need
From the map.
on a piece of property from a future land use map. It's it's a broad category. You have to go to the next step and look at how the property is zoned. And most people buying property, certainly developers, that's the question, how's the property zoned?
So they go to the map and then they'll go to zoning
Right.
and see how it's zoned under the commercial. Okay.
This is a good place to start. It's a good place to start. This gives you an idea.
Sure.
Commercial, manufacturing, residential. You know, it gives you a good overview of the town. You
Yeah.
can start here.
Okay, so then they would go from the map to the zone.
So,
Then I have a more specific question. In the green on the underneath map, at the very top, you're recommending Brushy Brook going to open space, but since it's RFR 80 now and they can do, gabillion houses on it, it sounds like we're talking about economic viability is a problem. That would be, we really can't do that by taking their economic viability away?
well, by making that open space and allowing active recreation uses such as golf courses or horseback,
yeah.
anything, pools, anything active recreation, they could make money.
I can understand that, but I think it seems to me, and I would agree with you, I'd like it to be open space, but I can understand the owner's perspective that that's an enormous drop in economic viability. And the economic is really dropped radically. And I would assume that they would have not just the right of appeal, but they'd win. So how do we handle a space like that? I don't know how to handle it.
Let me just jump in if I can, Madam President. I think you centered in on probably the biggest concern that this council had in conforming zoning and future land use map. And it's when you're removing so many uses that it approaches the line.
Sure.
Where that line is, I couldn't define it. No one can. I know what the language says, all economic viability. That's an easy call. But what does it really mean?
Mhm.
I think courts have different, and I don't know that anyone can give you a better answer. Taking all use away from Brushy Brook's lot by making it open space would be an obvious thing. So
Right.
that's a no-brainer. I don't need to think about that for seconds. But once you start adding in some uses, you get away from that line and move to something else. How far do you need to go away? I can't tell you. But you should proceed with caution because every instance where that occurs, you open the town up to litigation.
Sure.
And when you proceed with caution, it doesn't mean you can't do it. It means that you need to look at what you're doing and why. Is there a reason for that parcel to be open space with active recreation on it? I know some limited things about that parcel, so I could suggest that there's DEM property that's used solely for hunting, fishing, things like that, nothing else, that borders two sides of that pond. There are other open space areas in that general vicinity as well, so it seems to fit well with the neighboring use. Is that alone good enough? I don't know. But those are the kinds of things that you need to be thinking about when you're changing the zoning. Does it make sense given what the surrounding area is? Are we doing this for a reason? Is there something particular about the topography of the land, about the resources that are on it that justifies the decision that you're making? It's not as easy as saying you can do it yes, or you can do it no. You need to think about it and analyze all of those things when coming up to a position of the conclusion on what to do.
I know when I take a look at the first map, Jim, the original one, I know when I take a look at some of the properties, 413, 765, 764, the big purple, I can understand it going to manufacturing light industry from commercial. I don't think there's a very big economic drop there. If anything, it may actually become more valuable since our nearby land is in manufacturing light industry. I see less of a problem there, but I certainly see a problem with the Brushy Brook, especially since there's a big residential swath that borders it that is not suddenly taken over into green space too.
If I could just give you a little historical perspective on that though, keep in mind, this is not a recent addition or change to this map. every future land use map that I've looked at that preceded this, that particular parcel was open space / conservation. So this is a continuation,
Well,
okay?
wait a minute, when you said that every map, that was originally PUD, way back in the 90s. So why do you keep calling it open space? It was a PUD. I was on the
Yeah.
council then.
You're right, it was made a PUD, correct. And we ruled that expired because they didn't start work on it. Yeah, it was a PUD. That's a
Right.
zoning change, but the
Right.
comprehensive plan, future land use map, the one that preceded this one, done back in 1990, if you look at it, it says open space conservation on that. I don't think that was ever changed officially, even though the PUD went into place. And I guess for the time that was valid, I guess it was a valid development option for it. But anyway,
Back to you, Barbara.
whichever way you decide to go, it's either make it yellow, or we have to change the zoning to be consistent with the green. So it's entirely up to the council.
Well, I think with Sylvia's point on the PUD, I think as a PUD, it was as a golf course,
With
which is
houses.
active,
With
which is
residential
active.
condos,
Right,
condos
but
and
it's
golf.
active recreation effectively with the condos, so it's a combination. So it can almost go back to not original, but its prior PUD, which was active recreation with condos because it was a golf course. Then you have economic viability without turning it into passive or active recreation only. It still has some residential components, but it can stay as more open space than perhaps they would like.
And one of the other things that you may want to consider, it's pertinent to this particular parcel because planning board's heard so much testimony on it. In particular, a state representative came down there at one of the hearings and talked to us about the impact that any residential development would have on the use that exists on the neighborhood next door.
Sure.
How it would limit hunting and whatnot. So those are the kinds of things that you all over in your mind when you're considering the change, whether or not it's justified. Including what impacts it may have on the surrounding uses.
And then my last question is on, again, the first map. You're suggesting us putting in the mixed-use village as a category. And I think that was from prior.
As it exists today.
Yeah.
This is the current future land use map. Mixed-use village is on there. It's been on.
So that's something that you would like us to establish, even if I may not want to see so much of it.
Well, again, even though it's on the future land use map as a classification, we have yet to define what the mixed-use village is.
Or whether I even want it in some areas. I mean, I just want to know if that's part of the discussion, I'm sure, down the pike, whether, because we don't seem to be able to sell that. It's an unsellable point, and I certainly don't want a huge piece of property unsellable, especially at the Exit 1 development, which has the commercial and manufacturing light industry. I might be far more interested in light industry, manufacturing light industry, which I think is much nicer to be near neighborhood business. So we have the ability to discuss those parcels specifically and change them.
You do it, and you have the other things on your comprehensive plan and the future land use map. So to the extent the council decided that mixed-use village is not a concept that we're there, or I suppose you could eliminate it completely.
Or you want less of it.
Yeah, I don't think I want to eliminate it either, but I think I definitely want less of it. It's just not sellable. If it was sellable, I'd be happy, but it's not sellable. And we really need some tax base, so I want it to sell. So that is my concern with Exit 1 and Exit 2, because those are actually our economic zones. And so my concern is making sure that something can go there physically, so I can tax them.
You all set, Barbara?
Yeah, I think that's my last question on
Scott,
that.
do you have anything?
Yeah, one of the things, I'm going to mention three things, and one is also the mixed-use village in my sheet notes. I'd like to talk a question on the law on prohibiting things in all zones. I think of the adult entertainment issue many years ago that...
Can we get to that when we get to district use table?
Okay,
So can we hold off on that one?
can I ask a general question on that?
Yeah, we'd rather get to district use table, because
Well,
that's where the wrinkle is.
I'd like to have a comment on any type of activity that's prohibited in all zones, anywhere in the town, and what the legal issues are, out and out prohibiting an activity that somebody might want to establish, but is prohibited in all zones. What is the legal problem with that?
I think Madam President suggested we address that at a later time during the discussion of the law. And I'll certainly address that in great detail at that time, but there's certainly some cautionary issues that we want to address. It's not something we want to use as a blanket matter. We want to consider that very carefully. So we'll address that, Madam President, legislation.
Okay, and then one other thing with home businesses, and we'll get to that, because I noticed there's some businesses that people could operate out of their homes, like a beauty salon or accounting services and things of that nature. The other thing is the definitions of a mixed-use village. But the history of that issue stems from the Pawlowski report, I believe, when many years ago we had the big box debate in town, maybe around 2004. And that was one of the suggestions. But I just remind people the economy is cyclical, and zoning always stays in place until you change that zoning. So the economy is ever changing, and zoning stays there until you change it. And that's all I have to say at this time. Thank you.
On the kind of follow up with what Barbara was talking about, your when she mentioned Bushy Brook. The green areas, when you had mentioned to me that you wanted to start it made perfect sense. We're going to have an open space district. And it made perfect sense in my mind that there would be the DEM properties, the conservation, you know, the nonprofits or for-profit, whatever they are, but they're state, town, they're land trust, they're open space. It's easy. Yeah, it's easy. Call it an open space district. But when you start taking somebody's property and putting it in open space, that is not okay with me. And it may be that maybe that one parcel up there, the Bushy Brook, maybe there's something unusual about that, but still, they had a residential use, even as part of the PUD. So I don't want to see hundreds of homes all of a sudden on a property, but to single a property out, or if there are any other properties, I think the easy thing would be to identify it, the permanent DEM, town, land trust, those, and they're easy, they go in. But when you start with some of these other properties and then just making them part of it, you're going to have a problem. Unless that property owner raises his hand and says, oh, I definitely want to be in open space. So that's what I think on that subject. And I think there were a couple of others somewhere here and there.
You know, in the same neighborhood, these properties up here, for example, are listed as open space, as they have been in previous maps. There are single-family homes on them right now. So those are the ones where I suggest to take this green out and make it yellow, make it residential, such that we don't make those people non-conforming. So the council may decide to do the same with the Brushy Brook parcel as well.
The other thing I wanted to ask you is, when you were talking about, and Barbara had brought up, you know, what's easy, and I think that they all have wrinkles, but exit one up is just going to take more time. But they all have wrinkles. When you talk about, for instance, zoning for what's there, let's take Hope Valley. And if you have neighborhood business, and apparently neighborhood businesses aren't liked by upstate or something, they don't like neighborhood business.
I do.
I mean, they don't like the classification, they want us to name it something else or something?
No, the state has nothing.
Oh, they're not telling us it's, okay, let me tell you what my concern is, so then you can follow up.
Mm-hmm.
If we're going to look at Hope Valley, let's say non-conforming, there's non-conforming uses. And I think there are some in Hope Valley and they're neighborhood businesses, but they may also have non-conforming uses, but they're labeled on the zoning map neighborhood business. I would be very cautious about let's say there's something there that's really a commercial, but they are non-conforming, legally non-conforming, I would be hesitant to then suddenly just make them commercial, because then everything that's commercial can be allowed. Right now, they're limited. They can only do that legal thing that they've been doing, or they can do neighborhood business. So I think that's an area that I don't think that's going to be really easy. And I think you had mentioned before there was a way that Charlestown was looking at it. They were going to, there was going to be a different class, there was going to be commercial, but then there was going to be another classification, commercial something else. I don't mean commercial special, but commercial light, or I don't know what it.
Well, the way Charlestown does it, they have C1, C2, C3.
Oh, okay, there you go.
And basically, it's depends upon what sort of a highway you're on. Okay, C3 is your more. That's how it goes. C3 is like on Route 1, US Route 1, highly
So,
intense.
yeah.
C1 is like the equivalent of our neighborhood business, serves the neighborhood. So we call it something different, but no, the state has nothing against neighborhood business.
Oh, okay.
They just say that for purposes of the future land use map, they want to see that designated as commercial. When you get to your zoning map, make the zone neighborhood business.
I don't understand the thinking. Why in the future land use map you would want, they would make us put commercial, and on our zoning it would be neighborhood business, and then there's going to be a court case in the future, and then it turns everything upside down again?
No, because neighborhood business is a form of commercial development.
Right, right.
It's like
not
having
inconsistent.
C1, C2, C3.
Okay, so when they
We're
say
just calling
commercial, it
names.
doesn't necessarily meet our definition.
Right, don't
Oh,
think about
oh,
zoning.
all right, okay.
That's why I tend to refer to this as classifications.
Okay.
This is not a zoning map, and these are
Right.
not zones.
Okay.
These are classifications, land use classifications.
Okay,
I have a follow-up question.
yep.
I have a follow-up, leave it if you could there. I have a question then. In the green space across from Brushy Brook, where you said there's some residences, now, you have it on the map as open space. They are now actually a residence, which would be yellow. If they sold their house, and they sold to a person who wanted it as a house, they continue being residents even if the map says open space, right? Okay. Now, if they sold that instead of to another residence, they sold it to someone, or they gave it to the land trust, and that still has a house on it that the land trust obviously can use. But if it goes to the land trust, then effectively it goes to the green permanently, which is what you already have on your map.
That's how it's structured right now. Yes.
I don't know if that would be true. The issue that immediately occurs to me is whether that would be an abandoned form of use, just by virtue of transferring the property to the land trust may not necessarily be abandoned. It opens up a whole lot of issues with that. I think the cleaner way of looking at this is fully, do you have a reason for making those residential lots from residential to commercial? What is it? And not excuse me, for residential open space. What is that reason? And in particular, when you're selecting a change to those lots, I would caution you to be very careful, because that's opening yourself up to an area where if you take too much away from it, you want to take, that will be reversed like work. So you're going to be very careful in changing those as you have to.
So that would be an area, if it's already houses on, it's a green space on our map, but it actually has a house on it, so it's actually residential, that it should become yellow. Because that is what it is, and we're really not changing that.
That's what is proposed by the planning board, correct?
Yeah, that makes
That's what I
sense.
suggested. Yep, right.
Because if it's there, and that's one of those spaces where you know what it is, and we're changing the map to reflect what actually exists. That makes sense to me.
Yeah, that's one of the easy changes.
Right, easy is good.
I would say.
Right, okay.
So we have one quick.
Go ahead, Frank.
Jim, can you refresh my memory? Which zoning classifications did the state want changed in the comp plan? You know, like the neighborhood business, they
Right,
want.
let's
How
not
many-
say zone, let's not say zoning classification.
Okay,
Let's say these are
land use.
Land use
Yes, land use
classifications.
classification.
Okay, these three right here, for example, well, we have commercial, we have highway commercial, which presently, on our future land use map, this is the area owned by the Randos, okay? we never went forth and changed the zoning on those to reflect highway commercial, okay? As you recall, we changed the future land use map for exit 1, but when it came to implement the zoning changes, we took a time out to reflect on it, and I guess we never went back to it. So we don't have a zoning district, highway commercial. We have a classification on our future land use map that we may struggle to deal with at some point in time if we don't rectify it. So, so anyway, and then again, we have neighborhood business. Those three, commercial, highway commercial, neighborhood business, they all fall under the classification of commercial. And that's why over here, we made all of that red.
Sure.
Okay? Now, that's not to say that we can't come up with a district tomorrow, highway commercial, and make that highway commercial, because that would fall under the red. Okay? Again, the state doesn't like manufacturing and manufacturing light industry. They feel as though this legend right now reads like a zoning map legend. This legend should appear on a zoning map, not a future land use map. There should only be a handful of classifications. When we want to define how we want to develop this town, we do it through our zoning ordinance. And you know, I might add this too. Not just does our zoning map have to be consistent with this future land use map, but the text that's in our zoning ordinance has to be consistent. Both things, the map and the text, have to enable this future land use map to come to fruition. There can't be anything inconsistent in zoning. Right? We have to enable this to come to be.
So, I'm hearing two different things. I'm trying to wrap my head around this. Future land use map and classifications. What it's telling me, what I'm hearing, is it directs the town, the council, planning board, directs who's ever in office or on a committee or a board to move in that direction. So if you've got red and it's commercial, even though it's not zoned that way, it must be zoned something similar to that in the zoning map, but it says commercial on this future land, or it may on the future land use map. So that holds true, of course, for all around town. So if you've got these fewer classifications and you don't have neighborhood business and they don't like it, so you don't have it, and you have commercial, people are going to look at that future land use map, and rightly so, because it's going to direct or lead the discussion into making your zoning map similar to your future land use map. So when you do that to the future land use map and you just put commercial, but it's really neighborhood business, I have a problem with that.
If you can look at it, I think the way I look at it, it's like a subset of that.
Yeah.
So it's a subset of the.
But it has to be, if it
use.
is, I understand that it would be a subset because it's a business, it's commercial, it's just a neighborhood commercial. Somewhere that it makes me feel better if somewhere that is described.
You know, I think that's
So
the
that
point.
future people aren't struggling and
Well, it
just,
would be in zoning.
It may be in zoning, but what I think she's saying too is
it's
that
not defined now.
It's not clear.
It's not clear now, it's not
clear.
defined.
And I understand too, you know, I understand Charleston with C1, C2, C3. That makes perfectly good sense.
For them, yeah.
But if you have, but for us, our C1, C2, C3 would be highway commercial, commercial neighborhood business. We just have names instead of C1, C2, C3. But it would be really nice if on this map, the future land use map, there was under the legend, you know, and under commercial, that they have the following zoning designations. You know, in Charleston, it would say, you know, check for C1, C2, C3. But here we might say commercial, neighborhood business, because those are the only two we have, really. Because we don't have a highway
I think
commercial.
that's what the state wanted to get away from.
Where that would
I
be
know the
further
state
elaborated on
I know the
is-
state wants to get away from it, but I think what's happening is that the people don't read it.
Well,
You
I
know,
mean,
the state may like it, but real human beings may not be able to function with it.
if you look at the future, if you look at the comprehensive plan, and you look at the land use element, and you read it,
Yeah.
the land use element will explain that
Sure.
this land use classification is further broken down in the zoning ordinance as neighborhood business, highway commercial,
Sure.
and commercial.
Oh.
That's where, you have to read these documents, okay? I mean,
You forget.
You can't put everything on a
You
map.
forget.
On a legend, you can't.
On a legend.
Okay, that's fine, as long as it's in there.
And again, most people know, I mean, it's more, I mean, I would suffice it to say that more people are familiar dealing and talking about a zoning map than they are a future land use map and a comprehensive plan. This
You
is
got that
almost
right.
like Greek to a lot of people.
Makes
And
me-
we're
makes
all
us
in the
nervous.
business here.
Yeah.
Imagine how a total layperson, but that total layperson out in the field is probably gonna come in and say, how's my property zoned? Because they're conditioned to ask that question. That, you know, and I think the state has recognized that with the last legislation they passed, is that, hey, zoning rules. You know, you can fool around with this future land use map to your heart's content, but, you know, when somebody owns a piece of property and it's designated as zoned as such, and you're gonna try and tell them that they can't use it for what the uses are allowed there, you've got big issues. So, zoning's where it's at. That's where, if any, you shouldn't really be afraid of this. This is a general, broad, just something to get you in the ballpark, okay? The details, the specifics, that's like the fine print. That's where you go to your zoning ordinance. That's where it's spelled out.
Okay.
And most people know that, I think. Yeah.
Okay. So I've limited, you know, we're gabbing a lot, and you guys have already gabbed, and I wanted you to hear what's on our minds, because you probably brought up some of the same sorts of things, but if we're all set, you basically have had our say. Harvey, you had something to say, and anyone else would like to chime in.
We have a little bit of a discussion the planning board did about.
What's that? Yeah, if you could come up closer to the microphone. I know it picks us up. As long as if you're loud, it's better.
The planning board did have a discussion about the open space, and I think they came down with something that was pretty simple and easy to understand and less controversial. At Brushy Brook, they actually have a master plan approved for a residential project, and so I would assume if they decided they wanted to actually build that project, that they're all set to go ahead. So you're not doing I certainly wouldn't say that's a taking. They have a project with 150 houses, or I forget what the number came down at. It was a little bit unknown because it was based on doing a yield plan, but so I think that's an important thing to take into consideration, that you're not just taking a project that somebody wanted to do something and you're changing it. And right now it's a raw piece of land. And certainly if you looked at what is most compatible with that piece of land, I mean, you certainly can justify that it's, you know, it's surrounded by DEM protected land. So it certainly makes a lot of sense for it. And then they had the discussion about the fact that up in that neighborhood there are a number of small houses and stuff, you know, on smaller lots and stuff, and there are already houses. We know that's not going to really be open space. So I think the split that the planning board came up with was, in my mind, very appropriate after they had that discussion.
So your thinking, Harvey, is that and the planning board's has been that you'd like to see it on the future land use map as open space, recognizing that there's already a project going forward, and unless that project fails, if it fails, then you're saying it would revert back to...
And the fact that if you look back at the history of that, you mentioned the PUD, and we've had, several bankruptcies on that property, people trying to develop it. They've apparently given up on the idea that a golf course there is viable. So it really comes down to maybe its best use is open space. And if they can't make this project that they have approved go forward, then what else are they going to put on there? I mean, they can't, environmentally, we've determined that they can't put any more houses on there than they already want to put on there. So, you know, we've reached the density maximum, so I think they're at a point, if they can't make that one work, what else are they going to use it for? It's not going to be manufacturing or something.
The problem is it has to do with philosophy and
Right.
property rights. It has, if you own that piece of property and you want to put houses on it, and then, oh, that project didn't work, so I'm going to go figure something else out, and then you find that the town is zoned at something else.
I
and
heard
you're
you
like,
and
wait a minute, I want to put houses on it. It's my property. Why can't I? So
And-
you can't, it's a big deal to do that.
And so they do have a project approved for a lot of houses, more houses than you could put on there if you were splitting it up into RFR 80. So they actually have a higher density right now.
Yeah.
But they can't sell it as a residential
That,
space. If it's not developed, they decide they're not gonna do the 150 houses, and we have it as open space. When they sell the land, they have to sell it as open space, don't they? They can't sell it saying, hi, you have approval for 150
so,
houses.
so there you have an issue that
Yeah,
you
that would
have
be
to
a big
deal
issue.
with. That's a little
They
bit
would be very
different.
unhappy.
I don't believe that's true.
No?
Can you have to come up to the microphone because your
Yeah.
voice is very, very quiet.
I'll tell you, I haven't really considered that carefully, so I'm not going to give you a definitive answer, but my gut instinct tells me that, let's assume the current owner, LR6-A owner LLC, decided it wanted to sell the property. Whatever rights it has to develop it, to the extent it has any, I don't know why it would go away just by virtue of the sale itself. So that if they have vested rights, they could certainly alienate those vested rights to another buyer who has economically backed interest in proceeding with the project and does. That's my gut. I wouldn't give that as a definitive this evening, but so I don't think that's the right way to look at it. And I'll add to it that Brushy Brook has whatever rights they have currently, whether that be under what the town approved as a conditional approval, or whether it be something that SHAB changes and decides they can build at the density they proposed and not what the town issued. It may be something in the middle. I don't know what their rights are, but they may have something. If the project is abandoned, however, and this town council decided that it wanted to change that land from R1 or RFR 80 to open space, then anyone else who owns the land, including LR6-A, if they own it at the time and decide to abandon the property's current proposal, would be stripped of some economic viability. So again, you're back to square one, which is the decision needs to be based upon whether or not you have a legitimate reason to do it on that parcel generally, and not necessarily how it'll impact LR6-A owner LLC. And the analysis is general no matter who owns it. It's, are you stripping an owner of all economic viability? And that's the real question.
But if those rights transferred to the next owner, Scott, you wouldn't be doing it, all right?
Maybe, maybe not. And again, it depends on whether they want to go forward with what the town has approved and if that's something the courts uphold. Or what if they wanted to come forward with a different proposal to build houses in a different nature and kind that did not include low and moderate income housing, and you've changed it to open space. In that event, a court may very well find that you've stripped the owner of all economic viability, depending on how far you've gone to take away uses. That's the analysis. So it's not as specific as you're making it. I think it's much more general.
Thank you. Is there anyone else who wanted to add anything? Okay. All right, I guess we'll move on and some more discussion. Is there anything else, Jim? You all set?
Well, I just want to point one thing out. You asked a question earlier, by looking at that map, how would you know? And one of the things that we've got to straighten out is, with respect to the property owned by the Randos here, okay, we see that the current map here says highway commercial there. That property is zoned manufacturing right now. Okay. So that's something, and even though we're proposing to change it to red, commercial, okay, that's something we've got to rectify, because right now you can't tell. I mean, you would expect to see that, even if it was under highway commercial, you'd expect to see some form of commercial. Property zone manufacturing.
I like that.
Well, when you talk about what's easier, I think that all of these parts, all the discussions, if you break it out into these 4 parts, they're all going to take a little time.
Sure.
Individually. There are going to be some quirks or some things that are going to come up we're going to have to struggle with or need more information. And I'd like to, while exit 1 isn't something we could do in a couple of months, I think, though, that I'd like to see us move toward working on that, because it needs to get done. That's how I see it. It's been put off, and there's people that are interested in developers, and we've got some nibbles on a couple of little things, and I'd like to see the town move forward on that. I mean, we can do the district use table and wrap that up and move that forward. There's just a little information we need to gather, and then I'd like to, and we can think about this too, but I'd like, you know, and maybe by the end of the meeting, we could talk about it a little bit more, but I'd like to see us go for exit 1 and work on that and try to resolve some of these issues. And I think some of it'll be, I think we'll be okay with the property owners, and those that aren't, we'll talk to them about it. So anyway, maybe it won't be as hard as we think.
I would also like to see the ones where we're giving them back to what they actually have.
Mm-hmm.
I mean, and just getting those done and out of the way. I mean, like the green that's actually residential, just make it what it is. And if they have no problems with it, and if you can talk to the people directly, we just make it what it is, and we get those accomplished via your office, if there's no argument, because if there is, they certainly can come in and discuss it with us at a later date. We're just trying to see what is the easiest things to just change over. Because I think if we can get those done, those are at least out of 100 parcels, you're down 20 or 30 and you're concentrating on the next batch. I think that seems like it should be able to be done administratively through your office. I think that might make it relatively simple.
I agree. I mean, I could call those people individually. And again, like I said before, I think in those cases where you change the future land use map to match up with existing zoning, you're not likely to have very many points of confrontation at all.
Right.
Because people, you know.
It is what it is.
It is what it is.
No, if there are some easy things that you think are there, I don't agree that they should be done administratively. I think that if you do the work and you come up with a list and you come up with, I don't know, whatever number, and the property owners are fine with it, then I think it needs to come back and we need to see the list and see what the changes are, and then stamp it okay. It could be an easy thing, but I would like to see that.
You are required by staff to keep it informed.
To do that,
You have to go through, so you have to go through that process.
Well, yeah, I guess you're right, yeah.
Officially, I can't do that.
Right.
I think I know what Bob was
Right.
getting at, is that if I was to have these informal chats
Sure.
in my office with everybody on that, every change I make, if make appointments, come on in, and then when we have our workshop, I can have a little report for you and say, okay, well, all these folks don't have any issues with this. These folks do, and we can focus the workshop on those people that do. Make more efficient use of our time.
Yeah.
And not only that, it'll give me a chance to explain, instead of doing it in a large session like this, I can explain to each property owner, as I've already done to a couple, by the way. When the lady came in on another matter happening in their neighborhood, they had a question on it. I said, well, why are you here? I said, let me show you what I proposed. And she had no issues with it.
Right.
Because she has a residential property there now, and she says, I have no intention of ever starting a neighborhood business on there, so great, make it residential. It's actually split. Split lots are very problematic. Split zone lots, or even split comprehensive plan lots. I mean, there's no, you know.
I don't know how it happens, yeah.
It's messy, it's messy.
Yeah.
But she had no problem. Matter of fact, this is down on Route 91, right by the fish market they just opened up. The front part of their property, it's on a side street there, right by the market. Front part of the property is classified neighborhood business. She has a home residence on the back part, which is residential.
Yeah.
She says, no, we're never going to start a business out there in the front, so clean it up. So, the more things like that I can clear up my office,
Right.
we can make more efficient use of our time here and really focus on the things that deserve our attention and deserve our thought.
Okay. Good. All right. Let's see, we can move on to the district use table, and I want to make sure we've all got the same copy of everything.
Do we have to give them permission just to do that?
What's that?
Do we have to, just all of us give them permission to do that?
I don't understand your point.
To do what he had just said, is talk to people?
Oh, no, he's going to.
I don't know whether it was a consensus thing.
Oh, sure, I'm sure we all agree, that's fine.
We all agree.
I didn't hear anybody
either.
jump on it, so, yeah. No, I didn't know what you were talking about.
So the consensus is do that.
Yeah, sure, if you can,
I'll try to move it along, just keep in mind,
It takes
between now and
time.
the 23rd of July, I don't know if I can get
Oh,
all
no.
100
No,
some
of
odd
course
people in
not.
my office. okay?
No, of course not, but
I'll be
Do your
busy.
best.
just move on it, because it's a quiet time. I mean, it is a quiet time, whether we like it or not. So the consensus is do it.
Yep. All right, district use table, we've got a couple of them. There is, let's see, I want to make sure we're all working off the same one. There is the most recent, on July 13th, we got a memo from Jim, who explained, and it's reference advisory opinion, and it has planning board discussion, and it also includes on the second page, he had looked at manufacturing light industry, because there weren't any dimensional regulations. Okay, so there's that copy, all right? And then there's also the March 2012 one, and it had manufacturing light, it had mixed use, it had open space. And I believe, Jim, this one, this must have been the one that went to the planning board for their final, okay, I think?
Yep.
So they were working from that,
Right.
and then they came, I just want to make sure I'm on the right page, and then they came up with this one, and they took off, this is your July 12th memo.
Yep, that's,
Yeah,
well,
yeah,
that's-
and they took off the mixed use,
And open
because
space.
we didn't, yeah, and
Well,
open space, because we
The date on
hadn't,
that is June of 2011.
Yeah, June
I
1.
I think the one that you might want is the one that's dated September of 2011. And again, it took off the open space, it took off the, I think that's what you want.
I know, but I don't think
oh,
we
I'm
have
looking
that.
at the wrong date. I was reading your memo date, and this, you're right, this one that you sent to us
This is
goes,
June
is
1.
back, is
Right.
June 1, 2011 at the bottom.
Right.
Yes, you're correct, yep, yep, and that's
So
this one right
is
here.
that the one you're referring to, Jim?
Yes,
Well-
this is the one that we approved, or through our workshop way back then.
He's saying September.
Well, I've got one here that says approved by the council planning workshop. This is dated 9/14, September of 2011. I got that one here. It should be close to the one you have.
We only have two in front of us, the 601 and the March 2012.
I just want to make sure we're all working off the same copy.
And I don't
Yeah,
have.
I don't have September.
I don't have 9/14.
Because I believe we had a workshop in September.
We
last
did,
year.
but, and if I'm correct, I believe that we had a workshop, but then the planning board took it up at their meeting, which would have, let's see, September, oh, I see what you, oh, all right, I see. The planning board looked at that in a meeting. And what copy would that be?
May, with a cover of May 9th. I remember the memo came out in advance when you set all of your workshop dates. You wanted to get this information early. He sent it out to us on May 9th, which had cover letter, and it also had...
May 9th, there we, oh, okay, I've got a May 9th, oh, that's the list of property
I've got
owners.
May 9,
And then there was a...
but I don't have a district use table. I don't have a district use table that's associated
No,
with
me
that.
either. Unless
That's
the May,
2012. And that's got the three classifications on there. I don't, that's not the one Sylvia's referring to. She just wants the one with the manufacturing light industries alone.
Well, this is the one we worked from
Yep.
at the workshop, okay?
What's the date of that?
This one that has all the classifications.
March
And of course,
2012.
we're going to ignore mixed use, and we're going to ignore open space. So this is the one we worked from.
I remember that.
Right,
So which
right.
one are we going to...
So let's tonight work from this one.
I don't know if everybody has that.
I have, she
Scott
asked us
does,
to bring it.
you do, and Frank does. We all
Okay.
do. Yep, we all
Are
do.
you
That's
sure?
the March 2012?
Yes.
Well, it says
Yes.
proposed use March
Well,
2012.
that's the latest planning board recommendation, March of
Oh,
2012
okay.
this year.
Yeah,
Not
Okay.
and this
September.
one doesn't have red on it. It's just
September of
red.
2011.
Yeah, yep, yep.
Okay.
Mine is
All
red.
right, so this, whatever that was in 11, this is what was brought
Well,
forward.
what's in red there, okay? The table you have
Manufacturing,
in red-
light-
Manufacturing, light industry,
Mixed use.
mixed-use village, and open
Right.
space.
That most recently came from the planning board. The council hasn't really seen that yet.
Okay, so that's a good one to work with.
Yeah, yeah.
That's good.
Okay.
This
And,
came from planning board, right?
And
That's a good one.
I just want to ask you now, this one. Take a look at that. You see your memo in the front. Open it to the district use table, because I think that when I went through this, I'll give you an example, there was something in here, it had to do with septic haulers, had to do with, there was something allowed in here, and I said, oh, I think we missed that, and I checked it off that I wanted to bring it up, and guess what? The planning board, at their meeting, caught it too, and they changed it, they recommended it, and whatever they recommended, I think it's underlined, or it's highlighted, I forget. And I think that's part of that memo. And I want to make sure that while we want to move forward with this, we recognize any changes the planning board brought up. So I'm going to refer to that too, to make sure we don't miss anything as we go through this quickly.
I reviewed this week.
Good. Okay, that's fine too.
Right,
But this
which
one's
is this
different.
one.
We're going
This
to,
one.
I know, we're going to have to,
So I reviewed the wrong, well, not the
No,
wrong
not the
one,
wrong one.
but different
there's
ones.
slight changes.
I reviewed the one that was with your memo of July, the June 1/11.
Yep.
What's the date at the bottom?
June 1/11.
Oh, June, okay.
Yeah, that's the one I.
There are ones that succeeded that.
Right,
Oh, okay, so that one in your hand is June
June 1.
11, right?
Right.
Okay, so we're not going to bother with that one then, because that's old. Because then we had our meeting in September of 11, and we went through the whole thing. Okay, good, all right, thank you. Then I will keep your memo and get rid of the rest. That's that, I don't want to get confused.
I got copies of everybody.
No, I brought one, this is March of 12.
Well, that's the most recent one.
Okay,
Come out of
so-
the planning board.
Yep,
But that's what the council, that's what came out of the council planning board workshop right there.
Was that 601,
9.
69,
Oh, that I don't have.
6914?
9/14.
Oh, 914.
Yes, I have, so.
What date is that?
this one is 9/14/11, where it's
Someone
just,
Immediately following your workshop.
yep, and this just took off, this one followed with this.
This might be
Okay, so
it.
we're going to work off both of these.
Okay.
Oh, okay, Lisa, I tell you what. So I guess the recommendation is that we concentrate on, your recommendation is to concentrate on 9/14,
Or
but
March
keep,
12.
Or March 12th.
or the March.
Okay, if you only want to focus on manufacturing light
Yes,
industry,
yes.
then the 914 would be. Now, the one March of 2012 that's in red,
Yeah.
the same manufacturing light industry is in there.
So
There's
this,
no changes,
Oh,
there's no
okay.
changes from that.
so these are the same, it's just that these have the columns.
The
Okay.
latest ones.
All I did was add two.
Yeah.
I added two more, open space and mixed use.
Right.
But why don't we go with the red then?
All right,
Because
so,
that's
It's gonna be a little easier.
yeah, everybody's reviewed this one. So we're gonna work off this. This is the March 2012, okay.
Good.
And we'll keep this handy, we'll just give this a glance and make sure we don't miss anything. All right, okay.
Say you found something right away, why don't you correct it? If there had been a discrepancy and the planning board had picked it up, is that on the March 2012 one?
It
So you
is,
can get that one.
well, we're gonna go page by page, and then when I see it, I'll look, because I know that was a change. All right, let's see.
And we're only doing manufacturing light industry, is that correct?
Yes, so basically, we had changed a couple of things that were in error. For instance, there were all Ns and then there'd be an S over at Aquifer Primary. We
But that
corrected a few.
corrected it.
Yes, so if we see any mistakes, we can correct those tonight. But I guess and I think it'd be easier to just go through them, I think we can go through them quickly. On page 1, I did have a question for, oh, no, I'm sorry, that's not for tonight, that's for, I was gonna ask you something about open space, but we're not dealing with that, sorry, forget that. All right, so I think everything's okay.
And we're only doing manufacturing light industry.
Right, so we had already gone, all right, there's nothing on 1 that pops out, everything was fine there. It wasn't page 2.
Wait 1 second.
Oh, okay.
I want to make sure, Jim, page 2, 1691 is office for uses 160 through 169. Remember we had the problem at High Tech about not having office in a manufacturing light industry, so we could do Westerly Credit Union, and they had to jump through hoops and for a special use permit.
Which line item?
1691.
69.
Yeah, now that's office for...
On the left-hand side.
Right, 1691.
Oh, okay.
Those numbers.
That's office for the prior, where there is a use category in this that says offices, period, for manufacturing light industry. We have to correct that. That was a major error. It was embarrassing.
What was the error? I'm not understanding.
We had to, the Westerly Credit Union came
Yeah.
into high-tech profile, which is manufacturing.
What do you mean they came into
They
high-tech?
wanted to.
Oh, they wanted
went
to. Tenant.
No, they are a tenant now.
Oh, okay.
They wanted to rent a space to do their credit and debit cards, which is an office, not a bank.
Yep.
There was no place in manufacturing where they could have just office. They had to jump through hoops, get a special use permit in order to move in. That was the most embarrassing moment, I think, almost of my life.
Yeah, but that says permitted though. I guess, am I right?
No, this is only permitted for the things ahead of it. Office for uses 160 to 169. That doesn't include what, for instance, the banking wanted to do. I just want to make sure, under manufacturing light industry, we certainly have a category.
Light office?
No, office work, office,
work or
whatever they want to do, banks, pharmacies, I don't care what they want to do. If they're offices, they can have a section of a manufacturing plant that maybe doesn't need its whole space. I don't care what they want to do as long as they want to be there.
Office/professional.
Yeah, any kind of, and
So there
anyway,
wasn't anything, obviously, there wasn't anything in here that allowed banking?
They didn't allow offices. So I mean, honest to God.
Is there
it was-
something in here that allows banking, though?
No,
It's
but I
not
mean, I don't mean
specifically
it just for banking. Jim, so I just want to make sure under manufacturing light industry, let alone manufacturing, that we have a space where our building and zoning officer can say, sure, you can go in there. You know, it was, you remember that.
You're
That
looking
was
for a
ridiculous.
generic office.
Like
Yeah.
office/professional.
Right, and I just, you know, it's under construction general contracting, but just something that's just offices. And, you know, you can do office work, whether you're a bank or a pharmacy or an insurance company, that you can choose to be in a manufacturing light industry area because they have like high tech, which is, you know, we actually physically have.
I have a question for you. Farther on, oh, I don't have page numbers, number 6, it's section number 6.
What is
So
it?
there are
What's the number?
sections. It's,
Six numbers, six something?
it's personal, business, and
Oh, I know, but
professional.
Is it 5996?
Oh, it's,
Because they do
it
follow
starts with
numbers.
60.
60.
And I
Okay,
see
got it.
finance. It says finance, insurance, and real estate. And it,
And it's a special use permit. I mean, we just ran into this. This was
oh,
awful.
all right, I missed what you were saying. It was allowed, but you're saying they had to get a special
Special
use.
use permit.
Oh,
For
okay.
doing something like
Right,
debiting
right,
credit.
Right.
608.
Yeah, but I mean, that was awful.
Yep.
That was a lot of money, a lot of wasted time. Zoning and planning was embarrassed that you couldn't just simply have an office. They can rent part of their manufacturing space to a place that wants to do business.
So let's just change it to permitted.
Yeah. But finance, insurance, real estate, but what about any other kind of office? Like
You're saying
pharmacies, offices for a pharmacy, offices for an insurance agency.
Yeah, can we talk about the personal services?
Yeah,
So,
I was just pointing out that I was trying to find where
Yeah.
banking wasn't allowed, but that wasn't your issue. Your issue was just not allowing offices.
Yeah, not
Can
allowing-
anyone think of any reason why you wouldn't? Are there any offices that, do we need to be specific, or you?
Well, I think our zoning ordinance here is trying to differentiate uses that are appropriate in commercial zones versus manufacturing. Keep in mind, high-tech is zone manufacturing.
Check.
So, okay, so,
Exactly, but it has many, many businesses. And we want to encourage that. I want the property across from them to go into more manufacturing and office businesses. I think it's fabulous if they do. We simply cannot make them jump through hoops for a special use permit for something that is a great job, wonderful, businesses that are coming in. They should be able to make it easy
So
for them to
one
do
thing we
that.
could do when we go through this page by page, as you brought up, and we started on page 2 and you stopped us, what we could do as we go through this,
Well, I looked at office.
look for these perhaps offices and decide whether or not they should be permitted instead of a special use permit. It seems like a no-brainer that it would just be permitted.
Right.
Okay, so let's keep that in mind as we go through this.
Because it was ridiculous.
All right.
Anyway, so office for uses.
If I can just bring up
Yep.
one quick point. I mean, I didn't really review this 2012. Don't you think it would be better if we actually, I don't know, did you review it over the weekend? I didn't. I just
The
think it might be,
2012, yeah.
right, it might be quicker
To,
to review it, give us time to review it so we can go through it, have one meeting and blast it out. Otherwise, I'm gonna be like, okay, wait a minute, I'm gonna be, I didn't
well,
review it. I
you
reviewed
reviewed
the
this
other
one.
Yeah,
This is,
it's a little different than this one.
how is it different?
Well, I'm looking at page by page, it's different categories, even on page 2. This one starts at forestry, and this one starts at mining. So it's all different, it's all in different order. I made notes on certain sections of the one that was this weekend versus the one that we're now going through. So it's totally new in different categories and different pages. So like, I don't know, I'm just thinking out loud here, but I reviewed the 6/1/11, not the 2012 March.
I know, but I think,
Well,
I'm...
this one is,
I mean, I don't know, I'm just thinking out
well,
loud.
Well, no,
you,
but I was-
but if you look through this one, are you missing a page? It starts with residential, this one starts with
Right,
residential.
but page 2 is forestry on,
He's right, it's different.
it's all different.
It's all different.
The pages are different, I see.
However,
Yeah.
the pages may be different, but if you go through on your notes, food and kindred, let's say meat products, you had a question, we would be able to take number 201, look at 201.
There's different pages that days.
Yeah, but the use category, the number in the use category would be the same.
Well, what I'm hearing from Frank is he's not comfortable.
Well, it's just that I think I'd be better served if I reviewed the one that I actually make a decision on. It'd be quicker, I'm thinking, but maybe I'm wrong. If everybody else wants to go through it that way, that's fine, but I'm just, I'm trying to go through with, it's not the same.
Okay.
I don't know, you guys, if you think you can blast it out, fine, but I didn't review this weekend, I reviewed this one.
Why don't we review
You tell me,
them-
you guys want to do it, I'll do it.
Why don't we review them side by side?
That's what I'm trying to do,
Well,
but
I-
the different page of
They're
not
different
the
pages,
same
they're just,
page.
but they are the same categories.
Right.
The use categories
Right,
are
so
still the
if you
same.
guys, let's try and we'll see
Well,
how it goes, if you want to do it.
We
That's fine.
have,
We're on the second page,
Right.
and it's mining 14, 141 through 182.
And
So
this is 12 through 168, forestry
Exactly.
to concrete. So it's
I
different.
know, but you're not doing page 2. Just look at 141 on the page that
Yeah,
you
yeah, I
did.
see that.
And just let's follow 141 to 182, so you can follow it on yours.
Well, then it's page 3.
It doesn't matter what page it's on, just
Well, I know it does to
go
me,
by
because
the...
that's what.
well,
we're gonna
Frank's
be
not comfortable with this, so,
flip-flopping back and forth.
listen, we're gonna just end the meeting. He's not comfortable going through this, he went through the wrong one, and
Oh, it's just.
I think
the-
everybody, I
Well, no,
understand.
I went through the one I was instructed.
Okay,
to go
I
through.
understand that we could sit here and we could bang it out, and I'd suggest everybody go home, and we could just stay here and do it, and Lisa would stay, and the camera would keep rolling, and you guys can all go home. And we could work on this for another half hour, but we're not gonna be able to bang it out tonight, because Frank is not comfortable, and going back and forth.
I just
so-
didn't review this one.
No, yeah, so that's okay. But, so why don't we let everybody go home and we'll tinker with it a little bit more. Not quite everybody, but, does that sound good? Why don't you go home? Why don't you go home, Jim? And we'll tinker with this, all right? Everybody, good night. We'll tinker with it a little longer.
Jim should stay.
Yeah, maybe Jim should stay. A little bit longer.
Address that question you asked.
Oh, yes, thank you. Yeah, there is an issue with, hopefully we could move forward with this. And I had mentioned in the memo whether or not we could, I'd say outlaw, but whether we could ban specific industry if we didn't want it in our town. And you have an answer for us.
I do, and
like much of what I've been saying tonight, I'm not going to give you a black line ruling on what you can and can't do in that regard, but I'm going to give you what is the state of the law and some advice. So I talked to you a little bit this evening about when you're dealing with zoning issues, you're exercising the police power. And you know, at common law, things were a little bit different, but now that we have this police power in zoning, it puts in the town council's wheelhouse the right to make decisions on what people get to do with their property. And that decision-making process is governed by what's in the best interests of the public as far as the health, safety, and general welfare go. That's the plain language of the law. So the question becomes whether or not you can decide that a particular use is of a nature that there is no place in the town for it to exist, or it is so noxious or for some other reason that it's simply not allowed in your town. Ban it completely. And I think the answer to that is there are very limited circumstances where the court has allowed such a thing to occur. And it's interesting in doing the research on this, it brought me back to some of the areas of law and I guess of life that much of us prefer to avoid. It brings you to areas like what Mr. Bill Hurst raised in his question, which was the adult entertainment industry, which has been heavily litigated going back as far as the city of Renton and the United States Supreme Court and so on and so forth. It also brings you to the sale of cigarettes, and it also brings you to issues like the Department of Corrections and where you're going to put your prisons. They generally are things that people don't like to have in their town. So the language is there a reasonable relationship between the exercise of the police power and the health, safety, morals, and general welfare of the town? Some of the things that have been upheld as complete bans are the sale of cigarettes out of vending machines. Why? Why is instructive as to what you can do? Because there's a law that prohibits the sale of cigarettes to people who are under a certain age. And the only way a city or town can regulate that is to ensure that nobody gets to walk up to a machine that can't check your birth date and buy cigarettes. So that one's kind of common sense. And there are other areas like that that are just as much common sense as that is. No need to debate whether or not that's a ban that can be upheld. The difficult ones tend to be the ones where you're talking about things like adult entertainment, because they not only encompass an activity, they arguably encompass speech. And that opens up a whole litany of other things to be concerned about. What the courts seem to be doing in that regard is not allowing so much a ban per se as much as allowing regulation of it either through licensing or placing it in particular areas of the town where it's maybe better suited, or limiting where it can be placed based upon its proximity to other things like residences, churches, things like that. But those decisions are never made simply because the town council says we think it's so. The fancy languages, and I told Patricia Bugbee I'd be using this language tonight because she hates it. It's a Latin phrase, ipsi dixit, which I happen to like. Ipsi dixit.
Ipsy Dixie.
Because I say so is essentially what it is.
I like that.
I like
I should
it.
use that with my
Pat
kids.
doesn't. So, you know, I told her I'd use it and then I'd have to explain what it was. But that's what it means. So you can't just decide, I don't want, for example, a truck stop in the town of Hopkinton because I don't like them. That's not a supportable decision to make. There has to be much more in play to it. And there may be particular reasons for doing it in this town for any use. I'm not going to give you a specific use. Pick one. There may be a reason why there is no legitimate place for that use to exist in a town. But it has to be based upon facts, things that an expert would have to come in and look at in order to well justify the town in banning it. Because that truly is the most restrictive thing that you can choose to do. And if you think about it, as a citizen of, espousing a particular use, you're going to want to challenge that if it's a complete ban with no justification, versus the more or the less restrictive approach of maybe licensing it or regulating it based upon its time, place, and manners, the way they put it in the law. But where is it going to be? What is it in proximity to? And when can it operate? Those are things that you can well do instead of banning a certain activity. But all these things have to be fact-driven. They can't simply be arrived at based upon something that you decide is appropriate. And it has to be based, again, it goes back to the general language. And is there some reasonable relationship, or some courts even go as far as to say substantial relationship, which is farther than that, to the health, safety, and welfare of the citizens of the town, the reason why you're doing it.
So if we wanted to ban truck stops, and we wanted to do so because we all have wells, and we don't have water systems, then we would have to get, I understand we could look to the planning board to see what, when they had their meetings with the truck stop that was being proposed, whether or not there was any testimony in there that was expert, that on the town side, that substantiated why. And if we're not satisfied that we have what we need in there, then we need to hire an expert witness that will justify why it is we want to ban, if we want to ban truck stops, why that is. And that would be an issue of water. It's basically, I think, it, unless there's some other reason.
I think that's exactly
but
right.
Who would be a qualified expert?
Well, it's an interesting question. And the answer is not as simple as, pick a hydrologist.
That's why I'm asking you.
Yeah, and I couldn't say in a vacuum who the appropriate expert could be, because it depends on what issue you seize upon. You chose the aquifer, for example. That can be a number of people, including a hydrologist who may be concerned with recharge of the aquifer and how a truck stop may affect it, whether there's gasoline sales on the property and how that would affect the quality of the water in the aquifer. There's a number of issues that opens up immediately in my mind, and that's not one person. As we found, for example, in the Love's truck stop application, there were a lot of experts on all sides of that project that came in to have conversations on whether or not it was appropriate. And I can tell you that in my mind, I'm not 100% certain that the testimony would support or not support a truck stop, solely by virtue of the experts. And I think one thing that I would add to that is that what turned the decision was the way that property was zoned, or at least labeled on the future land use map, which under the law at the time was controlling. So that's an important distinction, and certainly drove a lot of what was happening in the Love's project that didn't necessarily address directly whether a truck stop fits over an aquifer. That's a more general question. And it's something that I don't think you're going to find the answer to in the minutes of the Love's proposal. I think that the most careful thing that this town council can do, to the extent it wishes to ban any particular use, is to generally discuss in the first instance why. What are you doing it for? Is there something peculiar to your town that makes it a use that should be prohibited? Is there something peculiar to the land or topography in the town, the citizens of the town, the uses that exist in the town? Seize upon something. Come up with a general reason as to why. Once you have that answer, then you know what the issues are generally, and you know who the experts are that have to answer the questions. Is it because you're worried about your water quality? Well, okay, that's hydrologists, principally. We're going to want to know, how is this going to impact the aquifer? And I would certainly lean heavily upon Mr. Lamphere in deciding who else may be appropriate or not appropriate to hire as experts. But it may not be one person, and it depends on how many issues you raise. But again, I can't say it enough. When you start to ban a use, the minute you start doing that, if it's a use that people are interested in, you're going to open yourself up to litigation, and you've got to be certain that you can justify what you're doing based upon actual studies and reasons, and not just because you said so.
But the justifications are subjective. Like what we may think as a group may not be the folks that Loves or some adult entertainment company. So ultimately, I don't know that you can even avoid court, because I think two sides are going to have different opinions.
Right, and I think one of the prime examples is the city of Renton case where, you know, of course, we're dealing with adult entertainment, and the way the court turned on that case was essentially that there was actual studied material. There was something they could go back on and say, this is scientific, statistical. We know what impact adult entertainment establishments have on crime rates, on police activity. We can look at the cold, hard data, and then we can say what the council did in restricting where it could happen, when it could happen, in what manner it could happen, made sense in relationship to those concerns, those statistical, raw data concerns we can wrap our hands around. It's not just because, you know, 5 people sat in a room and said, I don't like adult entertainment. That's not good enough. I don't like truck stops. That's not good enough.
Are you privy to what happened in Richmond? They turned it down right at the highway entrance. It's not near any schools, churches, it's commercial, and it got deep six. They just got pushed away and never got approved.
Well,
I don't know if they're in litigation, I don't know. But
I don't know either, but I'll tell you that oftentimes those kinds of anecdotal examples end up being not very good ones because we don't know the whole history. And I don't know whether or not it's something that's currently being litigated, that is the denial, but you know, there are a number of examples of projects that have come before the planning board, the zoning board, and elsewhere in this town where there's been a denial, and it's based upon things that will open up the town to litigation, but it's the right thing in the view of the people sitting in the chair. Sometimes it's not turned upon what the law will and will not allow. Sometimes a decision is turned upon what those 5 people think. And ultimately, people like me have to fight it out later on. So don't simply rely on Richmond as an example of what we could do. You know, I would much rather have this council look realistically at what the law allows and make its own decision. Because at the end of the day, if you people decide that a ban is appropriate, you know, we're going to tell you what the law says, but you're going to make the decision. I don't.
Yeah, I'd like to see us move forward on that and on what it is we don't want in town.
Right.
And the only thing that comes to my mind is the issue of truck stops. And if there's something that's not allowed in town, and people want to do something, and one of the things they do is they look at your district use table and they decide, okay, I'm interested in doing X, Y, or Z, and they start looking, they're like, oh, and then they can't do it. So we don't get a Loves. We got a Loves because they thought they could do it. But if it's in here that you can't, but you're saying you got to substantiate why you don't want it, and I say if we don't want it, then we determine why, like he suggested. Is there any other issues, and Jim might come up with some, is there anything else other than our problems with our concern about the aquifer and the water? If there's something else, because you can't just say traffic, because there's probably somewhere it could go, so
Sure.
Traffic's not making
And
it
the
easy.
key,
Then if we want to move forward, then we can move forward and we can find out who the experts are.
and the key language is right there for you. It's, you know, like I said, the health, safety, and welfare. So what about a truck stop would compromise the public health? Maybe the water issue seizes upon that. What would compromise the welfare? It could be traffic conditions. It could be
What's that, Lisa?
Noise ordinance.
it could be noise. It could be a lot of those things. So you need to seize upon those things and consider which of them are important enough.
What's that, Barbara?
We need to strengthen them so that we can depend on them, because right now we can't depend on them. They're not strong enough. As far as, Scott, I know you brought up the X-rated. We do have the ordinance for X-rated. We were one of the first towns in the area to do it. We did the council before our 6 years, the one before that. But we had to allow it in a manufacturing zone, so that we had a place in town.
That's what they do in Providence.
It could be allowed, but then it has other, ramifications we put on it. And Richmond's problem in particular is that they started to discuss banning them or, putting them in certain areas. And this came in on top, right on top of their discussion.
Yeah, that was where the big address.
Right.
My concern is,
We have it already, we were
Bob,
started.
as far as the truck stop or anything else, that when you completely prohibit any activity throughout the town, that, legally, you cannot prohibit like a truck stop or anything, really.
That's not what I heard.
You can literally do it, any activity throughout the town in all zones.
Yeah, so what will happen is, generally speaking, when you, let's say for argument's sake you did it.
But I thought that was probably too.
Generally speaking, let's say you did it. You banned truck stops because you're able to prove scientifically that they're harmful to the aquifer, and you can seize upon that issue in and of itself. The question then becomes, is applied to the particular parcel that eventually becomes an applicant, does it work? So we know there's areas in the town that are primary aquifer, and we know there are areas of the town that are not. We used to call them secondary, and I think now we just call it not. But whichever it is, you know, could an applicant who exists on the not come and suggest that the ban is not enforceable as to him because it's unconstitutional? Certainly could. And the reasoning for why you banned it on a primary aquifer lot would not apply. So it has to be supportable on a town-wide basis. It can't just be on parcels, you know, A, B, C, and D.
Oh,
we
no,
can
it has
prove
to-
it.
If you want, if you're going to ban it,
You've
it's
got to do
townwide.
it. Yeah, and you've got
gotta
to
substantiate it.
got to substantiate it from start to finish on every particular reason. And certainly, as I said, the ban is the most concerning from my perspective because it's the hardest to support. It's plain and simple, the hardest to support. You know, and you know, there are easier situations like the sale of cigarettes in a vending machine that are just no-brainers, but I don't think that a truck stop is one of those. I don't know enough about it at this point. I haven't heard what a scientific expert would be able to offer, but I certainly would be concerned because I don't see it at this point as being the same as a vending machine for cigarettes.
You know, Mike,
I was just going to say, technology is always evolving.
Right.
Okay, so what may be valid and upheld today won't hold true tomorrow. From a practical standpoint, if you're concerned about truck stops, keep in mind, a simple way to get around this situation is to rezone that parcel consistent with the comprehensive plan. Rezone it, right now, a truck stop is only, our zoning officer ruled that a truck stop is only allowed in a manufacturing zone. Well, from a truck stop operator's perspective, there's only a limited number of parcels in this town where I'm going to put a truck stop. That might be one of them. Rezone it. Take it away from manufacturing. You solve your problem without having to you know, present this major justification for banning it townwide. That's where they're going right there.
Well, if you're, and they get allowed where?
They're allowed in manufacturing
Right.
zones, but we don't have that many parcels.
Right, so they could look at a different manufacturing site. That's my point.
Yeah, but
If you don't want it, you know, my attitude is, well, certainly, there's a proposal now and they have a right to go forward no matter what we do tomorrow. They're still going to go forward and try to build it there. But if we end up doing a ban and we do our best to substantiate it, and then people want to look at our town to see what they can do, chances are when they see that something isn't allowed, are they going to start fighting then? They're going to fight when they think they can do something and you didn't ban it. That's why we have laws, because we didn't protect it. I don't know. That's how I see it. And if it becomes a legal thing, then you deal with it. But that's, I don't know, it just seems to make sense to not allow something right from the get-go.
What about, one of the things that I've heard on the zoning use tables is that if it's not in the use table, it's banned.
Yeah.
Well, obviously that doesn't sound like it would hold a bunch of water.
Unfortunately, people find ways to fit specific things in general categories.
Mm-hmm.
And it's one of the flaws of having a use table that doesn't envision everything possible, which is hard. It certainly is. But more particularly, doesn't have, you know, concrete definitions of things that people can seize upon or not. So I think perhaps one of the flaws of the old use table is just that, is that it's nondescript in many respects and, you know, certainly created problems. Mm-hmm. But I think my memory of Love's is that they cobbled together a few uses and ultimately were able to show that they were allowed to do what they were proposing under the use table. That's how they got it. It's not because they seized upon a particular area in the use table that said truck stop. That's not there.
Not there.
You know, we've got gas station, our
That's kind
service
of what I'm
station.
suggesting, or we look at those things that can be hobbled together and then you don't allow them anymore.
Well, but the other thing is, I mean, we do have in the budget that we're supposed to have somebody work with our sub-regs and our use tables. We need to get that person in. I mean, we're going to be making some decisions here, but that is the person that we should make some decisions, but work with that human being. I mean, so that we can get a use table that is more comprehensive than the one we have. Because some of the things, like the special use permit for an office, was ludicrous. So, I mean, I think that eventually what we need to do is, I'm sure it'll happen with the next council, not with this one, but we need to go forward and try to get some qualifications for that particular human being, because we're doing work that indeed they're going to be doing again.
Okay. All right, so next meeting, we'll be ready to do this district use table and get
What
this
date
done.
is that?
Should have said it, yeah.
Well,
23rd.
it's,
23rd.
yeah. And now, let's think about that, because the planning board agreed that they would meet with us, so they would want, they don't need to go through this, they've done this, you know, which is why they, you know, could leave, because they've already done this, and then we're gonna have to finish this, so actually, we shouldn't take that date, because that date is scheduled for a workshop with them. So what is it?
What are we doing?
Exactly, for what? So I'm wondering what we could work on with the planning board to move forward.
Well, keep in mind, that table that you have in front of you right there, March 2012, if you're only concerned with the category manufacturing light industry, that came right out of the 9/11 table. There's no changes in it. So you've seen that.
Well, I definitely
You
want
looked at
some
six,
changes.
you looked at the June one, Frank, okay?
Right.
If you looked at the 9 one, the September 2011 one, you'd be fine with that.
Right, I wasn't instructed to do that.
Right, okay. Right. So, but the only difference there is I added 2 other columns there, open space and mixed-use village. Now, I guess my question is, do you want to not concern yourself with those 2 extra zones and just focus on manufacturing layers, or you want to look at all 3 of them?
The easiest thing to do, because we're gonna get bogged down no matter what we tackle, we're gonna get bogged down with details, is one of the things that we were almost on the verge of finishing was the district use table with manufacturing light. And we've got a gentleman who wants to move forward with the project, and he'd like to go, and, Lisa? So, so anyway, the point is, if we could use that date, but that is a date the planning board would meet with us.
Beginning at 7 p.m.
Right.
We should meet at 6:30 or 7 or 6.
Oh, it'll
they're
take
gonna
us
have a
longer.
planning
It'll
board
take
meeting.
us longer. Yeah, because Barbara just brought up something that ended up taking some
Yes,
time.
focus.
You know, so something's bound to come up. It's just gonna take a little while.
But the council's already reviewed that column, manufacturing light industry. That came out of the council.
I know, but
Exactly,
we're
but
still
if-
gonna have to go over
Yeah,
it.
like,
So you want to go through it?
I want offices.
Okay,
I
okay.
mean, I just can't believe that we don't allow offices. I mean, they're arbitrary, but they could be a small part of someone trying to make a business function. And it is absolutely of no harm whatsoever to that particular category. There's a lot of commercial offices that can certainly go in manufacturing light industry, because that's just part of the businesses.
So that 23rd, is that a workshop, Sylvia, or is that a?
And I do like the idea that we could
Well,
look
it is
at
a
the
workshop,
open
yeah.
space and at the the mixed use.
All right.
I don't mind looking
I'd
at
like to
those as
say
well.
something.
Well, all right, go ahead, Scott.
You know, I was here tonight and I noticed that we had members of the planning board here. I know we had like a workshop maybe a month or so ago, and there was only 2 people in the planning board. If we have a workshop, we have to engage our boards with the council, and they just sat in the audience. And I think it's important for the council and our relationship with any board, and tonight it was the planning board, that we try to draw them into the conversation and ask for their input, because they just
We did.
were in the audience.
And we did, and the only one that spoke was Harvey, and, I mean, that's okay. And-
Maybe I overreacted
No,
by
no.
making that statement, but I think it's important, if you can have a workshop, you just don't have people from a board sitting in the audience, and there's no,
Well, I think the thinking was that from their point of view,
They
because I
worked on
talked
it
to
and
Al
presented,
ahead of time,
right.
was they had moved it forward to us. So their opinions were
Already there.
there, yeah.
So are we going to discuss as well then, I mean, I'm open to discussing mixed-use village and open space as well. I mean, we have it here. I think we should certainly concentrate on manufacturing light industry, but I'd very much like to look at the other ones too. I mean, if we're going to do just the use table, if that's your preference, although the use tables could change with the new person.
Eventually, it's going to, what person do you keep talking about?
We have the subregs and the use tables, that we have the $60,000 we've put aside in this budget to get someone to redo all the subregs and the use table. So the use table may change entirely. So we're doing something that I think may be done
we
over
have a
again.
property owner who asked for a zone change, and we met with him, and we went through,
Who is we and what person?
this council
I
met
know.
with
Who?
the planning board and some planning board members and Ray Dobbs. Remember that
Oh, okay.
workshop that we had?
Right.
That's what I'm
It's the Roy
referring
Dobbs.
to.
It's the-
Right, it's a Roy Dobbs
That's what
thing.
I just
Now,
mentioned. Who?
what I'd like to recommend is that we finish the district use table and only look at manufacturing light industry that we already did. If there are any specific things, like you brought up one particular thing, that's fine, but that we concentrate on what we've already agreed upon, and that this could then become our district use table. Now, we're gonna, yeah, and the way it becomes that is you're gonna have to advertise, you're gonna have to have a hearing, so there's a process you go through. Now, if we, at a later date, someday, the next council's gonna end up, and the next council's gonna end up looking at a mixed-use village and the open space element, which is not gonna go quickly, and so we're gonna end up looking at the district use table again. In the meantime, we'll be able to already have established what manufacturing light industry is. And of course, that means that we also have to have manufacturing light industry in our, I think I guess it was only the dimensional regulations. Is that the only place it's referred to? Or it needs to be referred to? Because we were gonna make sure that if there was any place else it needed to go. But the point is that we really are on the verge of finishing this.
But I mean, I don't see any reason why we can't.
Because it'll take too much time and it
No,
won't get done.
manufacturing light industry, I don't see where open space is that difficult.
Yes,
Mixed-use
it is,
village,
because there are
maybe.
properties that are not
Well, but we're not
open
doing the
space.
properties. We're only doing the use table, not the properties. The properties are over there. The use table does not reflect, it's not reflected by a particular
I
property.
can't do it unless I know what goes into open space. I wouldn't be comfortable doing categories, and I don't know what goes
But you
into open
can't
space.
A use table.
You see my problem?
Well, yes, but a use table has to do with if you have open space, this is what you allow or not allow,
Mm-hmm.
not who has which property. It doesn't matter who owns or has any particular property. If we have an open space that we establish, these are
Something,
things.
I can't decide this if they're not defined. I don't know what mixed use is, it's not defined anywhere. How am I going to decide what goes in it when it hasn't even been defined yet?
But in that
That's
case,
my problem.
then don't do mixed use, do open space. You know what open space is.
Oh, yeah.
I mean, I don't see where that's, I understand mixed use can be very difficult, I agree with that. But open space really should not be, and we're still gonna have this use table redone by the person who does the subregs and use tables. At least it gives them a
We
direction.
could probably do both, open space.
I think those are easy.
If you're going to do open space, then what are the open space? What is the open
Nature
space?
Conservancy.
If it's
Land
only,
trust.
if it's not properties, and it's not Bushy Brook, and it's not properties, if it's only DEM and those sorts of things, that's okay. Because if at a later date you end up deciding to add something else, that's fine. But if it's simple
Well,
and
at
clear.
this point in time, the only thing you're doing is going down that column and deciding what will be allowed under open space and what won't. As far as what particular properties it pertains to, that's not even a part of this at this point. I mean, but I think we know where we're going. We're only DEM, water bond, stuff like that, but.
But we know we're gonna have active and passive recreation in open space, but then later they'll determine which property goes to which category in zoning.
You don't have to designate any parcels
Right.
right now. on that.
Exactly.
You could have just a category with no parcels.
And it says open space, we can do this recreation or that.
Well, the
you
only
know.
way we'll know is to look at it. So I don't have any problem if anybody wants to look at it, and if it's simple enough, because I haven't. If it seems simple enough to do, that's fine. All I care about is that we don't get bogged down and we move forward.
In mixed use village is gonna be really.
Yeah, that'll
I
have to
agree.
come out.
I agree
So,
with that.
all right, so we're all in agreement that we'll look at this one,
manufacturing light
We'll
industry.
ignore mixed use, you can look at the open space, and if it is as simple as that, and we can get through it, then that's fine, I don't care.
I keep
Oh,
going,
yeah, that's fine.
because there's so much stuff that's just not allowed.
Scott, is
It's
there
open
anything you want
space.
else?
It's like the answer is
I-
no.
Anything
I wanna-
else?
I want to go to 20 Maple Court.
Could I,
I have nothing
I want to
else.
adjourn in anybody's memory.
at,
This is
Lisa,
a
will you
workshop, we
Please
can't adjourn.
establish your workshop schedule, you had a couple of dates in one,
Yes.
two, right?
Mhm,
You
yep.
could also continue to
The
those dates.
question is, though, the next meeting, the 23rd, is it the 23rd? That's scheduled for a workshop with the planning board. Now, are we at the point where we're ready to do something with the planning board? That's the question.
Oh,
They don't need to look at this
no, why don't we get our stuff done on the district use table, these two categories?
and not have the planning board come on the
Right, 'cause
23rd?
They've already presented, their ideas and everything is on that page, why don't we just? make
I mean,
our
that's
decision?
fine, we can let them know that they
I
don't
don't
need to
think we
come
need
that
to,
night
right.
unless, and, you know, it's just that they did schedule it and they did agree.
Oh.
I'm just not sure what,
Well, you know,
what we're
if
ready
they
to do
want-
with them, unless somebody could come up with a good idea.
Actually, it might be, I mean, they are scheduled to do that. I mean, if we go through, this is what they came up with, but if we are going to change it, which we are, they might have an opinion on why they did it
They're not
that
gonna
way.
sit here on the 23rd while we stumble through this. They're not gonna, that's why they left, because they're done.
Okay.
Now, if anything comes up, we can send it to them, but, so
gonna
the
change
bottom
it.
line
This
is,
is my
Lisa.
other suggestion.
Mhm.
You had originally also had the 12th of July as another workshop date, and when we spoke last week, we didn't think
We didn't need
had
it, yeah.
anything to fill in.
So maybe we should.
And that's Thursday.
And we could do the district use then.
There's nothing posted at this point, but you have to post 48 hours.
What did you say was the 12th, July?
Doesn't need to be-
Thursday.
Oh, that's this Thursday.
Yeah.
I don't need to be here until August 12th.
No, July 12th.
I don't want to do it.
I'm just throwing
Yeah.
options out.
We,
Madam,
yes.
I just wanted to suggest that it's my impression that the planner and the planning board both appreciated your comments tonight, and that Mr. Lamphere knows what he needs to do to move that ball forward as far as the future land use map goes. So I don't see the 23rd being a needed date as far as the planning board goes.
Well, that's what
For that,
that's why I'm stumbling, like, I can't think of,
There's nothing to do.
Well,
at this point.
initially, the purpose of these two workshops, and they were billed as joint workshops with the planning board and town council, as I understand it, the purpose is to go over that use table and the future land use map. And again, as Scott Bill just mentioned, to involve the board in a two-way conversation. Now, we didn't have that tonight because we kind of like changed our focus a little bit, okay? And we weren't going to get into specifics, okay? We're going to go into the use table. So really, we didn't do tonight what the planning board was maybe expecting. to
Well, I
get done.
did talk to Al ahead of time about the focus and how it changed. I wanted to make sure he was okay with it, and he was.
Yeah, oh, no,
No, I wanted to make sure you knew that.
Yeah, no, I mean.
But,
I don't mean
yeah,
anything
I understand.
disrespectful. or
No,
anything.
but I just want everybody to know that I did run it by Al.
I think where we're at right now, the planning board has spoken with that use table and that map. When the council's ready to engage them in a two-way discussion or something, I think.
About
that-
properties,
yeah, whatever that
specific
be.
properties.
Whatever you want to talk about, yeah. I don't think they'd be put off if they didn't come on the 23rd of July, to be honest with you.
Yeah.
When the council's ready. And that's the way we left it when it came to the council, is you pick the workshop dates when you're comfortable. Here's what came out of planning. It's up to you, it falls in your court. What do you
All
want to
right,
do?
then we'll have the 23rd, we'll go with the district use table, we'll tell them we didn't finish, so they do not need to come that night unless they would like to, but our focus is going to be to finish the district use table, and we're going to take up the issue of the open space column, okay? In manufacturing light, and just finish up the district use table, we'll do that on the 23rd. But the other thing I think you need to think about, and we could put this on the agenda for the 23rd to finalize it. On the 23rd, think about what we want to do next. And I hope that what we want to do next is to focus on exit 1. And when we're ready to have that meeting, we need to have a letter first go out to all those property owners so that they know on such and such a date, we're going to be talking about your property because you're in this exit 1 zone. And we'd like you to attend. And, you know, just a basic letter that goes to everybody, and then we can start. Okay.
We
Does that
don't
sound
know that
good?
date yet.
We just don't know that date yet, and it's gonna take time to get a letter out to everybody
We'll
and
be-
give them time.
We get the mailing addresses of everybody in that zone right now, ready to go. So we'll be ready.
Okay, all right, okay, we got a plan then. Thank you. Thanks for coming out tonight.
You're gonna adjourn